Hi guys, and welcome to part 3 of the law on extinguishment of obligations. Today we'll be talking about loss of the thing due. Now if you've been enjoying my videos and you want to see more, please hit the subscribe button. As a reminder for my regular viewers, this series is merely for educational or informative purposes and is not a substitute for proper legal advice. For my students, please be reminded that this is merely additional learning material and is not a substitute for studying and understanding the law. That said, when is a thing lost? Okay? The law says that a thing is lost if it perishes, goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. Okay? So, if a thing is lost, an obligation is extinguished. This is true if the thing is specific in nature, if the loss is without the fault of the debtor, and the debtor is not in delay. Okay? In such cases, the debtor will not be held liable for loss of the thing because the loss extinguishes the obligation. Now, loss will not extinguish the obligation and the debtor will be held liable, therefore, in the following cases. Okay? First, if the law so provides. One example, Article 1170 holds the debtor liable in case of loss where the debtor is guilty of fraud, negligence, delay, or of contravening the tenor of the obligation. Another example, 1165. If the debtor has promised to deliver the same thing to two or more persons who do not have the same interest over the thing. In those cases, the debtor will be held liable even if the thing is lost. And what will the debtor be held liable for? The value of the thing and, if warranted, damages. Okay? Second instance when the debtor will still be liable in case of loss. If there is an express stipulation to that effect, where the parties have agreed that the debtor will be liable for loss, then if the thing is lost, the debtor will be liable therefore. Okay? Next, if the nature of the obligation requires the assumption of risk, the loss of the thing will not extinguish the obligation, and the debtor will be held liable for the loss of the thing. Next, if the obligation to deliver a specific thing arises from a crime, in that case, the loss of the thing will not extinguish the obligation, and the debtor will also be held liable. Finally, if the thing is generic, then loss of such generic thing will not extinguish the obligation. Why? Because we have what is called the Latin maxim, genus non quam peruit, okay? Or genus never perishes. Okay? What does this mean, no? If the subject of an obligation is a generic thing, such as a sack of rice without any other specific designation, then even if the sack of rice in the possession of the debtor is lost, that will not extinguish the obligation because the debtor can still go and get another sack of rice of the same kind and quality. Okay? So in that case, where a generic thing is involved, the obligation is not extinguished by the loss of the thing. What if the thing is lost partially? The law says in case of partial loss, the courts will step in. Okay? The courts will then determine if the nature of the partial loss is of such nature as to extinguish the obligation. Because the partial loss may be so negligible or so small that it can be said that the substance of the obligation has been met, and therefore the obligation subsists. Or it can be it can happen that the partial loss is of such nature as to go into the substance of why the parties entered into the obligation. And in that case, the court will declare the obligation extinguished. Okay? Now, the law also establishes a presumption. What if, before the due date, the thing is in the possession of the debtor and is lost? The presumption that the law creates is that the debtor is at fault for the loss, and therefore, the debtor will be liable. However, this is subject to an exception, such as in times of calamity or other fortuitous events. Because the general rule in fortuitous events is that no one shall be liable in case of loss due to a fortuitous event. Okay? Just remember the exceptions to that rule in fortuitous events, such as when it involves a generic thing, and the debtor is in delay, and the others we have discussed before. Okay? What if the obligation involves an obligation to do? Okay? Earlier, we were discussing the rules on an obligation to give. Now, let's move on to obligations to do. When is there loss of the thing? Loss of the thing will extinguish an obligation to do if the service to be performed it becomes legally or physically impossible without the fault of the debtor. In other words, a law may have been created, no, or passed, which prevents the debtor to act in a certain way which is the subject of the obligation. In that case, you cannot blame the debtor for not being able to perform. Otherwise, he might be committing a crime or an act violative of the law. Okay, so in that case, the obligation is extinguished. Or if the service to be performed becomes physically impossible. Of course, in that case, since the debtor can no longer physically perform the service, then the obligation is extinguished. Finally, let's go on to an important article, 1267, which states that where the service has become so difficult that it is manifestly beyond the contemplation of the parties, the debtor may be released in whole or in part. This is akin to the principle of rebus sic stantibus. Under that doctrine, no, where parties stipulate in light of certain conditions, which if those conditions cease to exist, so does the contract cease to exist. A very good example of this rebus sic stantibus is contracts entered into during the Black Plague, no? The plague which was brought about by rats, otherwise known as the bubonic plague. At that time, before the plague, people may have entered into contracts, no? And at the time that they entered into that contract, they could not foresee or that the bubonic plague would hamper the roads of transport or commerce, no? In that case, they stipulated in the contract with certain conditions in mind which were present at the time of making the contract. Since the bubonic plague was not yet in existence at the time of the making of the contract, and the plague arrived, the parties may be released because they did not contemplate performing the subject of the obligation during the time that they entered into it, no? So, in case parties stipulate with certain conditions in mind that are the norm, and then additional conditions either arrive or the conditions before suddenly cease to exist, then the parties may be released either in whole or in part. Okay? So, that's it for loss of the thing due. Please wait for part 4 of the law on extinguishment of obligations. Thank you.